all stand and remain standing until the conclusion of the reading of the proclamation. Ladies and gentlemen, the proclamation. All persons having any business before this honorable court now draw nigh. Give your attendance, and you shall be heard.
Farewell ceremony is given on the occasion of the retirement of Justice Richard Weeks White.
I begin by acknowledging the Gadigal of the Eora Nation and pay my respects, sincere respects to elders past and present, and extend those respects to all Aboriginal and Torres Strait Islander people. This morning we mark the retirement and honour the very significant judicial contribution of Justice Richard Weeks White after more than 20 years of service as a judge of the Equity Division between 2004 and 2017 and as a Judge of Appeal between 2017 and tomorrow. This broadly coincides with the 50th year of His Honour's commencement of Articles of Clerkship. His Honour has produced a quite exceptional body of judicial work marked by meticulous attention to detail, technical brilliance, great scholarship, and a deep and abiding sense of justice. The quality of His Honour's work is perhaps only exceeded by his quiet modesty. I acknowledge the presence of Her Excellency the Governor, Justices Gleeson, Jago and Beach-Jones of the High Court, with an apology from Chief Justice Gageler, judges of the Federal Court of Australia and other courts, former Chief Justice Spiegelman and Alsop, with an apology from former Chief Justice Bathurst, and other current and former judicial officers from a range of courts and many other distinguished guests. Their presence is a proper reflection of the wide respect in which Justice White is held. I single out for special welcome Justice White's wife Catherine and their children Helen, Sebastian and Annabelle, recently returned from London. Justice White had the possibly dubious good fortune of having been appointed to the court in a year in which the president of the Bar Association was one I.G. Harrison SC, who introduced him at his swearing-in ceremony as having two interests, quote, cricket and the actuarial assessment of future claims liability, unquote. Asking rhetorically, how often in daily life does one meet an individual with precisely these passions? My research does not extend to knowing whether or not, as White J.A., His Honour has had the pleasure of upholding any appeals from I.G. Harrison in his subsequent capacity as a judge of the Common Law Division and more recently as Chief Judge. I'm sure that Justice Harrison will tell me, although he really doesn't mind being overruled. Now, to return to our subject, Justice White's career has been outstanding from the very outset, graduating from Sydney University with first-class honours and the University Medal in Law in 1976, before working between 1977 and 78 as an associate, or as the associate to Sir Nigel Bowen, the first Chief Justice of the Federal Court. Sir Nigel had, however, been Chief Judge in Equity before moving to the fledgling Federal Court, and it was in the Equity Division that Justice White was to spend the majority of his judicial life as one of that division's most respected members. Although articled at Allen and Hemsley under a Mr. William Gummo, who I see is here in whose presence I acknowledge, His Honour moved to Stephen Jakes and Stephen, as it then was, where he was rapidly made a partner before coming to the bar. It was actually at Stephen Jakes that we first met in the summer of 1983, as I was doing roustabout work in the firm as an office boy, having recently finished school, and was dragged willingly into the annual cricket match between Allens and Stephen Jakes. I cannot remember how many His Honour scored on that occasion, but I'm sure that it was more than the average number of speeches at a federal court retirement ceremony. It was certainly approaching double figures. I should add that this was not the occasion on which Allens hired Kepler vessels to push trolleys for a week so that he could play in the annual match, a fact that KWM just happened to recall in passing in its recently published 2-volume history. Early evidence of the future judge's scholarship, which was to become a hallmark of His Honour's judicial career, was supplied in the form of 2 very significant articles published in the Sydney Law Review, one in 1982 and one in 1986, entitled Enforcement of Foreign Judgments in Equity and Equitable Obligations in Private International Law, The Choice of Law. The latter was cited by Chief Justice Spiegelman 25 years later in Murakami and Moriarty, and has also been cited in the full court of the Federal Court, as well as in Canadian Intermediate Appellate Courts. His Honour's one-time Chief Judge in Equity, the Honourable Paddy Bergen, AOSC, has said, not in words to the following effect, but in these actual very words, which I know is your preference. And I quote, "White J, as His Honour was between 2004 and 2017, was the quintessential equity judge. The apparent ease with which His Honour reached the correct legal and or equitable outcome, supported by perfectly constructed reasons, coupled with the obvious joy in the judicial role, made him such a delightful colleague. White J was always destined to become White JA. However, His Honour's pivotal presence and enormous contribution to equity delayed that elevation. The Equity Division was indeed the very happy beneficiary of that delay," unquote. Examples of His Honour's contribution to the work of the Equity Division span the gamut of that division's broad jurisdiction, including probate, adoptions, trusts, property, breach of fiduciary duty, general equity, and all matters of equity practice and procedure, of which His Honour became a master. Many of his first instance decisions were reported in the New South Wales Law Reports and other specialist series of reports. Of particular note, His Honour served for a number of years as the Corporations List Judge, and his work in this area was exceptional and extensive, as a review of the Australian Corporations and Securities Reports will confirm. His Honour has delivered some 338 judgments concerning the Corporations Act, leading decisions, as identified by Justice Black, who makes the need for resort to generative AI utterly unnecessary in this area, include the following. Re Malopo Energy concerning company meetings and capital reductions. Re all class insurance brokers relating to the treatment of a broker's trust account in liquidation. The many ASIC and Sagala cases dealing with issues as to breach of directors' duty, freezing orders and contempt. Buzzle operations and Apple Computer, an extremely important case about shadow directors cited internationally by almost every intermediate appellate court in Australia and indeed in the High Court. The Shorten Crawley saga, a mammoth oppression case which resulted in His Honour publishing multiple judgments between 2005 and 2013. And finally, for mention, but only as an example, Super 1000 and Pacific General Securities dealing with indefeasibility and accessorial liability. This was the first decision after Farrer and Sadie which made it clear that in New South Wales, a statutory bar to a proprietary claim does not prevent a knowing recipient from being ordered to account personally as a constructive trustee, a position that was confirmed in 3 subsequent decisions of the Court of Appeal. Allied to His Honour's work in corporations was that undertaken in the revenue list, where a judge must, of course, be at once expert in the principles of equity and trusts, contract, property and statutory interpretation. His Honour delivered leading and oft-cited decisions in the areas of payroll tax, land tax especially, in relation to the exemption for land used for primary production, where many decisions of His Honour remain the leading decisions in the area. Vartuli and the Chief Commissioner, Metricon and the Chief Commissioner, Leppington and the Chief Commissioner, and finally Farella and the Chief Commissioner recently described, where His Honour sat in the Court of Appeal before his elevation and recently described as one of the critical cases in that area. Also dealing with stamp duty disputes, including scope of various other exemptions, assignment of rights under put and call options, etc., and GST. Since 2017, the Court of Appeal has had the singular benefit of His Honour's dedicated service and deep knowledge and experience, both generally and the great experience he brought as a trial judge. On the Court of Appeal, he's participated in the full panoply of work, sitting on almost 470 cases in seven years, as well as some 31 cases on the Court of Criminal Appeal. 500 appeals in a little over 7 years is an indication of His Honour's diligence as well as that of his colleagues. I should also note that His Honour continued to sit at first instance from time to time following his elevation to the Court of Appeal, and he delivered no less than 25 first instance judgments while a Judge of Appeal, notwithstanding the risk of a reversal by his peers, which occurred only once, 4%, very good average. And I wasn't on that case. Some, but only a small selection of His Honour's most significant decisions on the Court of Appeal included Rodney and Weisbrod, involving a discussion of the requirements for informal wills, distinguishing between the adoption of a document as a testamentary act rather than as expressing testamentary intentions. It's an important decision regularly cited in that area. Steinmetz and Shannon, family provision case, discussing the concepts of moral duty and community standards. Turner and O'Brien, returning to one of His Honour's areas of expertise, Barnes and Addy liability and in personam exceptions to interfeasibility. Anderson and Canaccord Genuity Financial case, an appeal heard over 8 days, in which the number 2 judgment on costs and litigation funders' premiums was itself a very lengthy judgment, soon to be reported in the New South Wales Law Reports. More recently, Zurich and the CIMIC Group, another multi-day appeal of much complexity dealing with insurance issues. I should interpolate there that to make reference to His Honour's earlier role as one of the senior counsel assisting the HIH Royal Commission. That was together with future Chief Justices Wayne Martin and Lucy McCallum and the future Justice Robert Beach Jones. Not a bad team. Other decisions in the Court of Appeal of note, Dagan and Fussell, again about the vesting of a deceased estate in the New South Wales trustee until the grant of probate. And in respect of that decision, Lord Justice Newey, writing for the Court of Appeal of England and Wales, recently referred to that as an erudite judgment. And an interesting case, Barrack and the City of Parramatta Council, concerning the power of a mayor and council to expel a councillor for an act of disorder, where the question was whether describing a mayor as a clown during a meeting constituted an act of disorder. I would have thought it was robust discussion, but I'm not sure what the result was. His Honour also sat an appeal on a case called White and Redding, a torts case involving an individual being hit by a tennis ball during an informal game of cricket in the function room at the Manly Lifesaving Club. The person who hit the tennis ball was also Mr. White, but I assume unrelated. This could have been His Honour's Bolton and Stone or Miller and Jackson moment, noting his love of cricket and indeed most sports. He was Sir Nigel's associate when World Series cricket and parish was decided back in the mid-70s, and he was junior silk to the late TEF Hughes AOQC in the South Sydney District Rugby League Football Club and News Limited litigation. He continued his connection with Tom on Tuesday when singing as a member of the choir at the great man's funeral in Rose Bay. In addition to judicial work, as with so many judges of this and other courts in New South Wales, His Honour has conscientiously served on a large number of committees and in positions over and above his heavy daily caseload. These positions have included membership at various times of the Supreme Court's Education Committee, Rules Committee, the Law Extension Committee, of which he served for a number of years as chairman, as he did as chairman of the Legal Qualifications Committee for a time of the LPAB. His Honour has, unsurprisingly, also delivered many papers and lectures during his judicial career, including on topics the position of executors before grant, knowing assistance, insolvent trusts, advocacy and the self-represented litigant, use of extrinsic evidence to control wills, Australian perspective of trusts and the nature of a beneficiary's equitable interest in a trust. All of which are, in and of themselves, great works of scholarship. I should finally also mention His Honour's service for the last 5 or so years on the Court of Appeal of the Kingdom of Tonga, where he has followed in the footsteps of Handley of the South Pacific. In that role, he has decided very significant cases involving Tongan constitutional law, electoral law in relation to disputed elections, defamation, contracts and shipping, criminal law, and land law, including a dispute relating to an entitlement to an allotment in the estate of Prince Tungu of Navatoka. On behalf of the Court, I thank Justice White most sincerely for 2 decades of exemplary service as a judge of this court and a judge of appeal. Very, very few judges serve for as long or produce a body of work of such enduring value. His Honour leaves a great legacy. He has been a valued and much admired colleague. As he sings his way into retirement and divides his attention between the golf course and the various choirs of which he's a member, we wish him a very happy and healthy retirement. Dr. Higgins, do you move?
May it please the Court. I too acknowledge the Gadigal of the Eora Nation. I give my respect to their elders past and present and extend that respect to all First Nations persons present today. Chief Justice Bale, it is an honour to speak on behalf of the New South Wales Bar Association to mark Justice White's retirement from this court and from a distinguished judicial life. Justice White, on behalf of the barristers of New South Wales, thank you for your long and varied service to the administration of justice in this state. As a young solicitor and aspiring wicket-keeper come batsman at Stephen Jakes and Stephen, things began auspiciously. Your Honour acted for the Australian Cricket Board in what became known as the World Series Cricket Australia case. One of Your Honour's early tasks was to take a statement from Sir Donald Bradman, then chairman of the board. Sir Donald, who was almost as fluent with the phrase as he was with the willow, once remarked, albeit not in that statement, and I quote, "When considering the stature of an athlete, or for that matter any person, I set great store in certain qualities which I believe to be essential in addition to skill. They are that the person conducts his or her life with dignity, with integrity, courage, and perhaps most of all, with modesty. These virtues are totally compatible with pride, ambition, and competitiveness." We will come back to that. Throughout Your Honour's almost half-century in the law, sport has followed you almost as ardently as you have followed sport. Having been called to the bar in 1986, Your Honour principally practised from 7th floor Wentworth Chambers. You there switched codes from cricket to NRL. Alongside the late Tom Hughes AOKC and David Jackson AMKC, Your Honour appeared, as the Chief Justice has mentioned, for South Sydney District Rugby League Football Club in celebrated and significant litigation concerning the application of then Sections 4 capital D and 45 of the Trade Practices Act 1974 as they applied to sporting competitions. Success in that litigation may have come second only to the evening when Your Honour attended the Redfern Oval, precipitating the game caller to announce excitedly that the Victoria's legal team was present in the stadium. It is said that the announcement, "and Mr. White is here tonight," was followed by one of the loudest roars of appreciation ever heard at a Rabbitohs game. Sporting devotion accompanied Your Honour to the bench, but by this point with an altruistic twist. While a judge of the Equity Division, Your Honour learned that a brother judge had been allocated responsibility as duty judge which would force him to forgo attending an important end-of-season home game of his favourite NRL team. Realising the stakes, Your Honour immediately picked up the phone and offered to sub in as duty judge. It was, of course, not all fun and games. Before taking silk, Your Honour appeared successfully as lead counsel for the respondent in the High Court in Chief Commissioner of Stamp Duties and Buckle, 1998-192 Commonwealth Law Reports 226. That case decided inter alia that the definition of conveyance in Section 65 of the Stamp Duties Act 1920 directs attention not to that which moved from the conveyor, but to that which was received or acquired by the conveyee by reason of transfer to, vesting in, or accrual to that person. As a young silk, Your Honour was appointed as counsel assisting the HIH Royal Commission following its collapse in 2001. It was there that Your Honour discovered the nice ability to cross-examine actuaries about assessments of future claims liability. To this day, actuaries across Australia shudder to hear Your Honour's name. It is perhaps not surprising that one so attuned to the exacting adagio of a 5-day test found himself so suited to the task. It was also as counsel assisting the HIH Royal Commission that Your Honour received your first recorded nickname. The press badged Your Honour the Patrician, in recognition of your patient, forbearing, and actuary tormenting manner. Your Honour felt greatly embarrassed by this, but would respond to frequent use of the name by colleagues, perhaps unsurprisingly, in a patient and forbearing manner. Following 6 years as a silk, Your Honour was appointed to the Equity Division of the Supreme Court. There, Your Honour quickly gained a new nickname. With shades of Benjamin Button, Your Honour went from the patrician to the Boy Scout, due to your efficiency, dedication, and hard work. Beyond a prolific garnering of nicknames, two threads that knit consistently through Your Honour's time at the bar and on the bench are an ecumenical intellect and a wish to educate. Your Honour's expertise in corporations, revenue, and commercial law was perhaps most richly supplemented during your time as a judge of the Court of Appeal. An early case that called for Your Honour's consideration was Gower in the state of New South Wales, 2018 New South Wales Court of Appeal 132, which involved a school teacher who had been injured when a student threw a soccer ball at him. Your Honour happily trekked the unfamiliar terrain of the Workplace Injury Management and Workers' Compensation Act 1998, the Workers' Compensation Commission Rules 2011, and the Civil Liability Act 2002 to resolve the issues in that case. In Cooper and DPP New South Wales 2023 New South Wales Court of Appeal 65, Your Honour considered the Drug Court Act 1998 on an application for judicial review by a drug-dependent offender complaining about a decision to exclude him from the drug court's rehabilitation programme. More exotically, as the Chief Justice mentioned, Your Honour spent time as a judge of the Supreme Court and Court of Appeal of Tonga. That court intervened with historic significance in the Tongan political system following national elections held on the 18th of November 2021. As a consequence of the election, the former Tongan Prime Minister, Dr. Tulone Toa, won his seat while his party lost the election. Allegations of bribery were made, and a first instance judge found that he had bribed electors and hence should lose his seat. Your Honour sat as one of a panel of 4 on the Court of Appeal, which on the 9th of August 2022 unanimously overturned that decision on the basis that the challenger had not proved all of the elements of bribery beyond reasonable doubt. Your Honour's abiding desire to educate has had both an institutional and an individual aspect. While at the bar, Your Honour was a member of the Association's Education Committee and later the bar's representative on the board of the College of Law for over 4 years, which included chairing its Finance and Administration Committee. While at the Supreme Court, Your Honour served as chair of the Legal Qualifications Committee and as a member and then chair of the Law Extension Committee. Your Honour's capacity to educate and enlighten on a one-to-one basis is revealed by the following direct, if unattributed, quotes from various of Your Honour's former tipstaves. First, my time with the judge taught me the importance of being correct. Second, I finally learned about gerunds. Third, the judge's patience with those who needed to be heard but did not know how to approach their case was a lesson in how to practice law with appropriate humanity. Fourth, I frequently think of judge whenever I find myself using a subjunctive in a conditional clause or a possessive before a gerund. Fifth, Chambers had a sense of serenity about it. Sixth, the judge taught me a lifelong appreciation of Chief Commissioner of Stamp Duties and Buckle. Seventh, most of all, His Honour taught me that while the devil may be in the detail, so too usually is the answer. All of Your Honour's chamber staff recall with great fondness the Friday night drinks you hosted, where the thoughts and reflections of the week were over a glass of wine, democratically and happily distilled. It is a great gift along the potentially solitary path of the law to be able to foster a community of endeavour in that way. Emblematic of Your Honour's personal legacy is HBSY Proprietary Limited and Lewis, 2024 High Court of Australia 35, which concerned the operation of cross-vesting legislation in connection with Section 153 of the Bankruptcy Act 1996, and in which Your Honour's former pupil, Condon SC, successfully led Your Honour's former tipstaff, David Smith, in the High Court. At Your Honour's swearing in on the 27th of April 2004, you remarked, "I feel the size of the task which awaits. I shall try to do my best." From the perspective of those who appeared before Your Honour, you met that sizable task with dignity, integrity, courage, and modesty. That was plainly compatible with ambition, and we hope, especially today, that it is also compatible with pride. Justice White, the barristers of New South Wales will miss you, but we wish you fulfilment in everything you now choose to do, be that nudging down your golf handicap, peering through binoculars at the New Year's test, or harmonising with the choir of St Francis's Paddington. May it please the Court.
Mr. McGrath, President of the Law Society. Do you want this?
May it please the Court. I would like to adopt the expression of my learned friend in acknowledging the Gadigal of the Eora Nation, the traditional owners of the land on which this court stands, and extend my respect to all Aboriginal and Torres Strait Islander people here today. Today, we are more than 20 years away from the moment that sparked Your Honour's highly respected judicial career. The moment in your old chambers when you received the call from the then Attorney General, the Honourable Bob Debus AM, asking if you would take an appointment to the Supreme Court. So much has flowed through these courts between the solicitors and the barristers of New South Wales and you, Your Honour, from that moment. Sometimes in life we are lucky to celebrate the sheer force of an intellect. Today is one such occasion. However, this may be more about Your Honour's clear intelligence than Your Honour has ever publicly averred over to in 2 decades on the bench, or indeed since being admitted as a solicitor of this court in 1977, or indeed possibly in your entire life. Modesty in relation to oneself has carried the day. Your Honour even stated when discussing your life and this speech, and I quote, "I don't envy your task, let me put it that way." But Your Honour, you yourself once wrote too that the ability of judges to decide truth from falsehood will vary according to circumstances. A healthy scepticism is in order. Although the subject matter today is not interpreting wills, I would invite the court to do the same here, because while Your Honour may be uncertain about what I say, this room is full of people who respect the power of your mind, which we are here to celebrate. I will take an example. One informant remembered working with Your Honour as far back as your university days. This individual is now a very well-respected senior solicitor who was an outstanding university student himself. Thinking himself smart enough when he joined the Sydney Law Review, of which Your Honour was then the committee chair at the University of Sydney, he very quickly realised Your Honour moved on a very different intellectual plane and was astounded to see a university student actively adding to the opinions of top barristers as if they were peers. As already referred to by the Chief Justice, articled with the then William Gummo at Allen and Hemsley, and an associateship to Sir Nigel Bowen, and then joining Stephen Jakes and Stephen in 1979, Your Honour had a top entry into the law as a solicitor, and soon you were appointed to the partnership in 1982. Growth in the litigation group at the time was notable, and the recently released 2-part history of King and Wood Mallison's comments on this, where Your Honour has your own entry in the index. After more than 4 years as a partner in the firm, Your Honour went to the bar, and your extensive practice was extraordinary, as this room full well knows. However, Recently, when asked if there was a moment when being a judge first appealed, the life of legal counsel emerged, and Your Honour replied, "It wasn't a matter of serious consideration, but it can never be. A matter can never be a matter of serious consideration for anyone, I would imagine, until an offer has been made." Nevertheless, amongst all the cases, your first matter on the bench has stayed with Your Honour, a matter of forgery, one afternoon in 2004. Without looking at your notes, Your Honour easily recalled the issue. The amount of payment recorded on the cheque stub unfortunately didn't match the bank statement. Of course, there were cases one can never quite prepare for, such as the longest case Your Honour has ever heard. The matter of Shorten Crawley at number 40 was the outcome of a 10-year court battle between two publican and hotel barons of Sydney. It ran for so many weeks that even a mind as prodigious as Your Honour's lost sight of the exact length. The trepidation at seeing the stacks and stacks of folders and documents in the case, however, left an impression. It was not easy, and even a judge as measured as Your Honour found, and I quote, "Mr. Crawley went to some absurd lengths to be obstructive." The case thankfully was instructive for others, not simply solicitors of this state, but counsel and even members of this bench. Of course, many cases that Your Honour heard made a major impression on the landscape of commercial matters, in principles of equity, estoppel, shadow directors' duties, in trusts, wills, and much more. I also know that considering many interesting points of law and the intellectual rigour of the Court of Appeal, and before that a judge of first instance in the Supreme Court, is something that Your Honour has been grateful for. And one can detect in the legal observation that Your Honour has produced a quality of observation only possible from an individual totally engaged by the subject at hand. One legally minded friend of Your Honour, tongue firmly in cheek, noted on this point that readership of legal judgments is minute, and that quite often the parties to the case don't read the judgment, they just go to the last paragraph to see what happened. Despite this view, Your Honour has bolstered the reputation of this court, and the Court of Appeal of New South Wales is widely considered one of the strongest courts in the nation and the Asia-Pacific region. Despite this fact, I'm told that Your Honour is an excellent singer in a renowned Catholic church choir. And on that point of singing, none other than the President of the Court of Appeal, the Honourable Justice Julie Ward, recalled first hearing Your Honour's beautiful singing voice after hours in chambers in the Equity Division. The President noted that Your Honour didn't hear her singing from her chambers, but did apparently hear her laugh quite regularly. The President also happily recalled first working with Your Honour many years ago as solicitors at Stephen Jakes Stephen. Since then, through to today, the President noted Your Honour as a gentleman, modest, and a pleasure to have called a colleague. Today, I am equally fortunate to represent the wider view of the solicitors in New South Wales, and to remark on our good fortune that the cases Your Honour has presided over, their influence and Your Honour's scholastic approach to law, are part of legal precedent now. Your Honour passes down a tradition from generation to generation, which has been influenced by the best of the law, by what Lord Mansfield wrote in Somerset and Stewart, by Frederick Jordan's major contributions to the practice of equity in Australia. It is just such a shame that in the millions of words Your Honour has published, it was discovered that there is a singular typo in a judicial essay from 2010. Given today is what it is, the slip rule may prevail. It would be remiss of me to fail to mention that alongside all this, there has been an impossible, tragic love for cricket, golf, rugby, and most sport. I'm told that during test matches, when with binoculars, one is best not to approach Your Honour for conversation. That Your Honour considers this the right time to retire, I have no doubt. Perhaps there will be more time now for days of blissfully silent test matches. Our members know the extraordinary contribution Your Honour has made to this court. Whatever comes next, on behalf of the Law Society of New South Wales, thank you, Your Honour, for your steadfast commitment and contribution to the law. As the court pleases.
Thank you, Mr. McGrath. Justice White.
Well, thank you all for your attendance this morning. Your attendance does the court great honour. I particularly thank Your Excellency, the Governor Margaret Beasley and Mr. Wilson, Jim Spiegelman and James Alsop, former Chief Justice of this court and of the Federal Court, Justices of the High Court, both current and former judges of other courts, former judges of this court, colleagues of this court, members of the profession, family, friends, and any curious passers-by. Chief Justice, Dr. Higgins, and Mr. McGrath, thank you for your kind words. Mr. McGrath, I have heard many speeches of presidents of the Law Society at the swearings in and out of judges of this court. Few have given more pleasure than the many speeches you have given during your term of office. Dr. Higgins, I scarcely took in a word you said. As always, I was mesmerised by the beautiful cadence of your voice, but I understood enough to know that it was unduly flattering. But I thank each of the three of you, not just for what you've said, but more particularly for what you omitted to say. On some occasions such as this, the audience and the judge are treated to a premature eulogy, rather than a frank appraisal of the merits and demerits of the judge. I'm very grateful that this is just such an occasion. Chief Justice, you mentioned when we first met, when you came from school to work in the accounts department of Stephen Jake Stone James. The Chief Justice was a very good cricketer, or Andrew Bell as he then was a very good cricketer. He had played for Grammar's first 11, or so I was given to understand. You did play in that game against Allens. I don't recall your feats on the cricket field on that day, but maybe they are now the stuff of legend. I don't know whether in his researches for the bicentenary this year, the Chief Justice studied a work by Jack Pollard called, quote, The Formative Years of Australian Cricket, 1803 to 93, close quotes. If he had done so, he would have read that in 1834, Chief Justice Dowling, over the objection of counsel, Dr. Waddell, adjourned a trial in order that the lawyers in the case could play an important game of cricket, presumably behind us at what is now Hyde Park. Those were the days, but they're unlikely to return. But I digress, which I should not. That is because we have it on the authority of Murray Gleeson, on the occasion of his retirement from this court on 18 May 1998, that Sir Lawrence Street decreed that for a farewell ceremony such as this, the retiring judge was to speak not for the purpose of making an address, but merely for the purpose of making acknowledgements and expressing gratitude. So I start with making my acknowledgement of the Gadigal people of the Eora Nation, the traditional custodians of the land on which we gather, and I pay my respect to their elders past, present and emerging. Sir Lawrence obviously intended that the making of acknowledgements and the expression of gratitude could be done shortly. I'm afraid you'll have to bear with me a little. There are three individuals whose tuition, example and guidance in my early years in the law were pivotal. The first was Mr. William Gummow, known to some of you as Bill Gummow, but to me, always, as Mr. Gummow. As you have heard, he was my master solicitor, and I am delighted and honoured that he is present in court here today. As you have heard, it is 50 years ago this week that I saw my articles of clerkship with Mr. Gummow. They had to be signed by us both before the prothonotary, and they had to be signed before the 31st of December 1974. That was the end of undergraduate articles of clerkship. So my cohort was the last of the undergraduate article clerks. I just completed my second year at law school. As we approached the Supreme Court in King Street, this place was then a construction site, Mr. Gummow said to me, "Well, Richard, and what will you say if the prothonotary asks, is this instrument liable to stamp duty?" He didn't suggest an answer. Of course, the prothonotary, Mr. Noonan, an apparently kindly man, didn't ask the question, probably because no duty was payable. But this was the first of countless lessons I had from Mr. Gummow to demonstrate to me that I just didn't know what I didn't know. For most of us, those lessons continue throughout our careers. No doubt there are a few exceptions, such as John Baston and Mark Leaming, and members of the High Court who know everything. The second individual was Sir Nigel Bowen, for whom I worked, as you have heard, for 18 months on the establishment of the Federal Court. He taught by example. In the late 1970s, there were some, and I emphasise some, courteous judges on the High Court and on the Court of Appeal. But their example did not then prevail. Sir Nigel was determined that the Federal Court should set a new standard, and it did. A few years later, Sir Nigel's example was followed by Michael Kirby when he became President of the Court of Appeal, and I'm honoured that he is here today as well. I doubt that there has ever been a better intermediate appellate court in this country than Justices Bowen, Brennan and Dean. I remember an exchange between Sir Gerard and Malcolm McClellan, then of counsel, on some abstruse point, where everything was so quiet, but the intellectual tension between those two great lawyers was electric. I don't remember what they said, but Chief Justice, I think that if it were relevant, my recollection would be admissible. The third was Gerald Rafterseth, the Queen's Counsel from South Africa, who was a litigation partner at Stephen Jakes. It is a testimony to Gerald's guidance that so many of the lawyers who worked for him went on to successful careers or to a stellar career, as in the case of our President, Justice Ward. I will pass over the thanks I owe to the solicitors with whom I worked and the barristers and clerks who helped me at the bar. But I must pay tribute to the late Tom Hughes KC. He was a giant of the bar. May he rest in peace. I have served under 3 Chief Justices, 2 Chief Judges in Equity and 3 Presidents of the Court of Appeal. Chief Justice Spiegelman was dynamic and a towering intellect. He took me to Shanghai for an insolvency conference in September 2008. His timing was propitious. It was held on the weekend that Lehman Brothers collapsed. As you would expect, there were many insolvency practitioners there from all around the world. The next morning, they had all fled. I thought either because they were needed or because they could not risk being seen not to be needed. Chief Justice Bathurst and Chief Justice Bell, in their own ways and with their own styles, have guided the court through the difficulties of flood, of COVID, of yet another flood, and into the uplands of the wonderful celebrations, Chief Justice, of this court's bicentenary. I'm indebted to both for their leadership and support. I served under 2 Chief Judges in Equity, Peter Young and Paddy Bergen. I had some trepidation when I was called into Peter Young's chambers shortly before my appointment. This was because I had appeared before him from time to time, felt like quite often, as a junior barrister. My record as a barrister appearing before Justice Young was unblemished. I had had no success whatsoever. I could not even get an order for short service. But he was immensely supportive of the new judge. So was Bergen CJ Eck, for whose support and friendship I will always treasure, and for whom I am grateful but highly embarrassed by her kind words that the Chief Justice relayed today. Because Sir Lawrence intended that these remarks should be brief, I will only say how much I have also valued the support and leadership of Presidents Beazley, Bell and Ward. There are so many others also to thank. There are the Justices of the High Court who, if I may say so, have given and continue to give to most of us assembled here the intellectual challenge of deciphering and reconciling what they mean. Perhaps more importantly, there are the judges of the local court and the district court and single judges of this court whose judgments come on appeal. In almost all cases, their careful elucidation and findings of fact and their analysis of the law eases the burden of the Court of Appeal beyond measure. This, in fact, is proved by the rare exceptions. There are the solicitors and counsel, without whose preparation and presentation of cases life would be unbearable. I also thank the registrars, the court reporters, the library staff, the registry staff, the executive, and others, without whose efforts the court could not function. Not quite finally, I must thank my many tipstaves who have assisted me for more than 20 years. Our relationships have been enormously beneficial to me, and I hope of some benefit to them. I will adhere to the general tradition of not singling out individuals for special mention. Some of you will know who you are. What do I then have to say of my associates? I have had only two. The first was Maria Basher. Maria was wonderful, whatever the pressure, and particularly in the early years in the equity division, there was a lot of pressure. She was unfazed. I was thrilled for her when, having put herself through the rigours of the Legal Profession Admission Board's course conducted through the Law Extension Committee, she moved into private practice as a solicitor. It was good for Maria. It was devastating for me. Fortunately, Linda Head stepped in with a wealth of experience. Her assistance has been invaluable. I cannot thank Maria and Linda enough. When I was sworn in, Catherine and my children, Helen, Sebastian and Annabelle, were sitting here, sitting much where they are now, but in their school uniforms. Now they are adults pursuing their separate lives and careers. Catherine and I could not be more proud of each of them. When I was sworn in, I said that a barrister's wife has much to put up with, particularly when he comes home. Didn't get a laugh then. Certainly not from Catherine. But now, as then, my love for Catherine and my debt to her is too deep for public exhibition. Thank you, Chief Justice, for this occasion and for the opportunity to say farewell. I have enjoyed my time on the court. I have been privileged to play my role, a very small role, in this institution.
The court will now adjourn.
All stand. This honourable court is now adjourned.